do I leave money to a charity in my estate plan? My name is Andrew Ayers. I'm an estate planning attorney with offices in Edina, Minnesota and New York City. And today we're going to talk about a portion of your estate plan that is important for many people. And there are two different ways we can approach it. Both ways have their pros and cons, but it's important that you know the two different methods you can use and figure out which is going to be best for your situation. So the two ways that we can easily leave money for a charity in your estate plan are, first of all, with specific bequests, and number two, bequests from your residuary estate. So if you're new to the estate planning world, if you haven't created a will before, a specific bequest is usually a portion of your will that's near the front, and it says a specific thing is going to go to a person, or in this case, a charity. So for example, we could have a specific bequest of $5,000 to the American Heart Association. So when your executor or your personal representative is taking care of your estate, these are the things that come off the top. They happen first. So before we distribute everything else under your will, we know that $5,000 is going to this particular charity. Now, for people who are involved with charitable giving, this is oftentimes a great way to make sure that that charity is covered under your will without having to worry about anything else. We specifically left that money for them, so we know that that $5,000 would go to them. Another way to do a specific bequest is a specific type of property. So you've probably seen commercials on TV for different charities that will actually accept your car. And I believe it's called Cars for Kids and other charities like that. So you can also use a specific bequest in your will so that your car would go to a charity like that. So that specific bequest is not only for money to charity, it can be for property or other identifiable assets that you have that would be good for the charity, maybe consistent with their mission. Maybe you have some collectibles that the charity could use or sell off for proceeds. The second way in the will we can leave money to a charity is with what's called the residuary estate. So the residuary estate is not where the money is initially distributed. So your will has specific bequests first, and then we'll have the next distributions in your estate, usually to your spouse or to your family members. But what happens if, for some reason, your spouse or your family members can't inherit? Maybe they've died before you, maybe there's some other reason they can't inherit your estate. Then the next place we look in your will is what's called the residuary estate. And this is a great place to leave your charitable donations if you have these kinds of concerns that you're worried about. So let's say you only have one child and the child's had some health problems and you're not sure what's going to happen. You can have a residuary clause where if your child dies before you and doesn't have any children or any other family, then what we can do is then whatever's left in your estate can go to specific charities. We can actually leave it, as opposed to money up front, we can leave 1/3 to one charity, so 1/3 to the American Heart Association, 1/3 to the Red Cross, and 1/3 to Cars for Kids, for example. Now, you should know that these don't have to be mutually exclusive. You can use a specific bequest up front for a specific item or asset or amount of money to go to a charity, and then also still have charitable donations in your residuary estate later in your will. So you can choose whether you want to use just one or just the other, or you can use them both in combination. So no matter how you want to put it together in your will, there's going to be different options, but it's important that if you have the desire to leave money for a charity, you understand these two methods. And I also want to talk about something that's not necessarily in your will, but something that may be helpful for you on this journey. So a lot of times my clients will come to me and say, I know I want to leave money to charity, but I'm not sure which charity. I'm not sure what's a good charity, what's a bad charity. Is there a way to rank them that one is better than the other? And if that's the situation you're in, then I would suggest you consider using what's called a donor-advised fund. And a donor-advised fund allows you to pool your money and you work with the fund for a specific cause. So you have, if you're worried about climate change, they can have a variety of charities that they can use your money to donate to. And you can specifically identify the charity you want it to go to, or you can just generally give them the money to be used for that specific cause. So when it comes to charitable donations, there's a lot of options out there for you. And it's important that you understand there's these different ways to do it. And you want to make sure that your estate planning attorney understands what are your goals? How do we want to leave this money? So if you just go to some website and fill it out, we don't know where they're going to put the charitable donations in. They may put that charity up front next to your siblings, and which doesn't usually make a lot of sense, when really what you want is a specific bequest. And it might not have the right checkboxes to actually have that charity be able to inherit as a residuary beneficiary under your estate. So we want to make sure that we've got the right wording and we're not just mail merging some form online. So if you're ready to get started, you can go to my website, andrewmayers.com, and there's a red strategy session button on the front page. If you click that, you'll be taken to my calendar. We'll set up a 15 or 20 minute phone call. Let's talk about your charitable donations, the strategies you want to employ, and make sure that your estate plan has all of those charities in the right place, and we know that your legacy is being honored in the correct way with your estate planning documents.